Hey guys, this is Scott Horne with the Owner Finance Network. I'm here to take a moment and talk primarily to our lenders, but also to our borrowers a little bit about foreclosures. Unfortunately, it's an event that does happen in our business and in our industry, and we want to ensure that, at least here in Texas, our lenders and borrowers understand the process procedure. One of the things we try to do here at OFN Loan Servicing is to be proactive on behalf of our lenders. Payments are often due on the 1st, late by the 10th or the 15th, but all too often the lender is relying upon a loan servicer to send out a late notice, make a phone call, do something to collect a payment. Well, months and months and months go by and nothing has happened. So one of the things we do at OFN Loan Servicing is to highly recommend to our lenders to be proactive. Take the time to call your borrower and see what's going on and track those payments so you can make decisions quickly instead of getting months and months and months behind in payments before you instigate a foreclosure proceeding. Now, one of the things we do at OFN Loan Servicing is within the first 30 days of a payment cycle, if the borrower is delinquent beyond their grace period, more than 10 days, we are going to start the pre-foreclosure process in consulting with our attorneys through Horne and Associates PC to send out that initial foreclosure notice to cure. Now, different states are going to have different ways and mechanisms of doing this, but it starts with that notice to cure the default. I'm certain that is fairly standardized around the country in all states. That notice to cure is going to be prescribed by your deed of trust or your security instrument. It may be a basic 20-day notice to cure, which here in Texas is prescribed by the Texas Property Code. It may also be a 30-day notice, or it could actually be longer based on what your deed of trust says. So as a lender, ensure you know what your deed of trust says from a collection perspective. So here again in Texas, we send out that initial notice to cure, and they will have either 20 or 30 days in which to cure the default, meaning to pay any arrearages, any attorney's fees, late payments, etc., in order to cure the default. Now, if they do not cure that default, as a lender, you need to be tracking that time frame so you know when to contact your attorney to go to the next level of foreclosure. Now, again, I am a Texas attorney. I am not licensed in their states, so I'm not going to speak to those states and their procedures at this time. But here in Texas, what we do is once that 20-day or 30-day notice has been sent, the borrower has failed to cure the default pursuant to the terms of that notice, we can then accelerate the loan. What that simply means is all principal and all unpaid interest and late charges are now due and owing. That letter has to be sent out by certified and regular mail as well. In addition, we will often include in that same letter the notice of trustee sale or notice of substitute trustee sale in the event there is a substitute trustee, and I'll explain what that is in a minute. The notice of trustee sale is a document that has to be, first off, typically filed with the county clerk's office and then posted at the place where they hold foreclosures in the county where the property is located. It may be at the county courthouse or some other spot that's been designated by the commissioner's court of that particular county. Once it's posted, it has to be posted 21 days before the first Tuesday of the month. And it's important to know your time frames because if we miss it by one day, you're off by another 30 days or more before we can re-foreclose. So look at the first Tuesday of each month. Starting on Monday as being day one, you can count back 21 days, and that is the absolute drop dead date that notice of trustee sale and notice of acceleration must be sent out by certified and regular mail and posted at the appropriate designated place in the county where foreclosures are held. Now, if you elect to use an attorney other than one who is listed as the trustee on your deed of trust, will have to complete what is called an appointment of substitute trustee. It's an easy form, and as a lender, you may choose to change the trustee at any time without giving notice to your borrower. It's just the simple fact of executing and notarizing a document and recording it in the deed records. And that substitute trustee will then be the trustee to handle and navigate the foreclosure process for you. Oftentimes, it'll be the attorney who's handling the foreclosure on your behalf. So once the notice to cure has been sent out and a default has occurred, once the loan has been accelerated, once the notice of trustee sale has been sent as well and has been posted at least 21 days prior to the first Tuesday of the month, then we wait for that first Tuesday. Now, one of the things that you should ensure that the attorney or the trustee does on your behalf is that they always check the title on the property. Because if there is a federal tax lien notice, we have to give the IRS at least 25 days prior to that first Tuesday of the month notice of the impending foreclosure. Once you do that, and if the property is foreclosed upon, that IRS lien is extinguished at closing, and then the IRS will have their 120-day right of redemption in which to cure and the default and come back and reclaim the property and pay off whoever purchased that property at the auction. Most other liens will be extinguished at the foreclosure unless there is a property tax lien on the property or back property taxes. So I always recommend to lenders to not only look at the title search for back property taxes and tax liens that may have been filed, but to research the taxes in the county tax assessor's website to see what's due and owing. And remember one thing, guys, many times a county may only collect county taxes, and the independent school district may collect the school and the city taxes independent. You need to check both sites to ensure you know what your county does in each instance. On that Tuesday of foreclosure, the trustee should be asking you for a minimum bid on the property. Oftentimes, the lender may want to appear or have the representative appear at the auction with their attorney as well or their trustee at the foreclosure time. At that time, the trustee is going to auction off the property to the highest bidder. That could be some third party who agrees to pay all cash at the auction for the minimum amount that the lender is asking for the property. It may be for some greater amount as well. But as the note holder, the lender, you also have the right to purchase the property yourself. Oftentimes, the lenders purchase the property for the balance of what is due and owing. But sometimes third parties do buy these properties, and when they do buy the house, they have to pay cash to the trustee at the time of foreclosure. Not the next day, not the next week, but within a reasonable time of the foreclosure. And that could mean up to an hour or so afterwards, as set by the note holder who is foreclosing. But once the property is foreclosed upon, the person who purchased it, whether it's an independent third party or the note holder themselves, they will then own the property. Typically, whatever property taxes are outstanding due and owing will be the responsibility of the note holder to cure and pay when they come due. Along the way, if the property was sold for an amount greater than what was due and owing the note holder, so in other words, the principal, all interest, any note holder reasonable administrative fees, and any attorney or trustee fees that might be incurred, will be subtracted from whatever was sold, the property was sold for at the auction. That amount of money that is left over belongs to the prior property owner who was foreclosed upon, and the trustee is to return those funds to them at the last known address. Or if it was a court-ordered foreclosure, we call those judicial foreclosures, then the trustee will deliver those funds to the court registry. So guys, I hope that helps you out a little bit in how foreclosures are handled. We trustees and we attorneys who handle this will prepare a trustee's deed, which will convey that property back to the note holder or to the person who purchased the property at the auction. And that will evidence that you are now the owner. So as you navigate foreclosures, understanding some simple basics help you understand the time frames and how to better interact with the borrower and the lender to best assure that these things don't happen. I have yet to ever find anybody that wants to be foreclosed upon. So take time, reach out to the borrowers, try to work out your arrangements and solve problems for everybody out there. We don't have to act like the big banks whose philosophy is no pay, no stay, with no options of workout at all. But we have options that are out there that can sometimes be very beneficial to both lenders and borrowers. So good luck. I hope that helps you guys understand the foreclosure process, at least here in Texas a little bit.